Hello everybody, this is Jeremy from Legal Studies Advantage. In this Success Tips video, we'll discuss what we call the Fundamental Legal Subject Matrix. This is a summary resource that has been assembled by those of us here at Legal Studies Advantage to help you to understand how many of the major subjects of law school fit together, how they're related, and how they're different. Let's take a look. Here in this matrix, you'll notice that from left to right in rows as well as vertically in columns, there are various associations between several different subjects of the law. The practice of law really can kind of be broken up into two major categories. Of course, there are many subcategories, there are many exceptions, there are many niche practice areas. We can't possibly discuss every single area and subject of the law, but what I want to provide to you is just a general overview of the practice of law, some of the subjects that you'll encounter in law school, and how these things all fit together. Now, the two major practice categories that I referred to a moment ago are litigation and transactional law. Litigation generally seeks to settle disputes, to enforce agreements and laws, and to repair harms. It may either be criminal in its nature or civil in its nature. So next to that, on the top left corner, we just read that box, elements of litigation law. Next to that, to the right, are three general categorizations of classes that you will likely see in law school. First, civil law. Examples of civil law categories would be things like contract law and tort law. Below that, we have criminal law. Of course, you'll probably take a criminal law course that basically discusses various types of crimes and the elements of crimes and defenses against enforcement of those criminal laws. And then below that, we have constitutional law. Of course, constitutional law has to do with the U.S. Constitution and its application to government bodies and individuals here in the United States. Let's go through a brief comparison of how some of these subjects may look different in a case that is presented for litigation. First, contract law. In this case, an injured party, the plaintiff, sues another party, the defendant, to try to prove that they are liable for a breach and to seek a remedy. Moving down one row, let's look at torts. In torts, the injured party, the plaintiff, sues another party, the defendant, to try to prove that they are liable for the injury and to seek a remedy. Those two are examples of cases that would be litigated under civil law. Let's move down one row. Let's take a look now at what a case would look like if it was litigated under the criminal law system. In this case, the government, the prosecutor, this is our P. We don't have a plaintiff in a criminal case. We have a prosecutor who represents the government on behalf of the people. In this case, the government, the prosecutor, sues another party, the defendant, to try to prove that they committed a crime and to seek punishment against the defendant. Note in this case that the victim of the crime is actually not a party to the case, but might be able to bring a separate civil claim in order to seek a remedy. So the parties in a criminal case are the government, via a prosecutor usually, and the actual defendant who is being accused of committing the crime. Let's move down one row now to look at constitutional law. Usually, a constitutional law case involves a private party, the plaintiff, suing the government to try to show a constitutional violation and to invalidate some kind of government action, some kind of government imposed law, some kind of restraint, and so forth. Now let's move over one more column to the right. The heading here says Rules and Laws for Trials. In a civil case, the rules that govern how that case is carried out are the federal rules of civil procedure at the federal level. In each state, there's also a set of civil procedural rules. Those may or may not be discussed in great depth in law school. Let's move down a little bit. In the criminal regime, there's also a set of procedural rules. I don't want you to get confused here, thinking that criminal procedure is what is applied in constitutional law cases. In a constitutional law case, typically, the federal rules of civil procedure will also prevail. However, criminal procedure as a topic and as a subject often has much overlap with constitutional law principles. That's why that box covers both criminal law and constitutional law. I didn't want to confuse the point here that criminal procedure is actually how a constitutional law case is carried out, but rather to point out that the subject of criminal procedure not only touches upon criminal law, but also has a great overlap and is governed to a large extent by constitutional law principles, such as the principles derived from a reasonable search and seizure, due process, and other principles that arise from the U.S. Constitution. Alright, under that same heading of Rules and Laws for Trials, let's move over one column. Here's a long column, Federal Rules of Evidence. Of course, each state also may have various rules of evidence. The important thing here is that you'll probably take a Federal Rules of Evidence course in law school. The principles of evidence will apply to virtually every case in court. I want you to note as well that while the Federal Rules of Evidence will apply in a federal court action, it is often the case that many civil law matters are actually heard in state courts. If these civil matters, such as a contract violation or a tort case, were brought in a state court, it is most likely that the state's evidentiary rules would prevail and be applied instead of the federal rules of evidence. Remedies has to do with the various tools that are available to courts to satisfy injuries to plaintiffs. Below that, I want you to note as well that there aren't traditional civil remedies available in a criminal law proceeding. Criminal law is all about punishment. If someone is found guilty of a crime, then the law imposes a certain punishment. Remedies are available under the civil law. Also, I want you to note that the outcome of a constitutional law case isn't typically related to punishment or remedies, but rather to validating or invalidating particular government actions that may be challenged in court. Let's move now to the bottom half of this chart. We'll try to move through this relatively quickly. Here are several examples of transactional law. Transactional law generally seeks to do things like reducing taxes and to prevent controversy or loss of assets in litigation. Transactional law is primarily civil, except to the extent that it is to plan to avoid criminal activity. Let's take a look at several examples of courses you may encounter in law school that have to do with transactional law. Please note, as we already stated, that most of these subjects fall under civil law. First, let's look at property. Transactional practice that touches on the area of property law generally has to do with planning the transfer of property ownership and the use of property by parties. For example, this may deal with sales, leases, easements, and so forth. Let's look at wills, trusts, and estate planning. This is another course that you may take in law school. This area of transactional practice involves planning for the distribution of an owner's property to others upon their death and the management of their affairs if they become incapacitated. Moving down the ladder here, let's look at contracts. Of course, we discussed contracts in a litigation context above, but here in a transactional law practice area, contracts would typically involve the negotiation of terms and agreements and creating contract documents that protect clients in the event of possible outcomes. Moving further down here, we have federal income, estate, gift, and GST taxes. Also below that are state and local taxes, income taxes, estate taxes, property and sales taxes, and so forth. Both of these are transactional practice areas, and they involve planning transactions and structuring property ownership with strategies that, among other things, result in tax savings. Finally, at the bottom of this chart, we have agency, partnership, corporations, and so forth. This is a transactional practice area that involves planning to reduce the exposure of assets of business owners and investors to liabilities that arise from actions of employees, independent contractors, business creditors, and personal creditors. In other words, this is the practice area that has to do with creating business entities and in using those entities to shield personal assets and to limit liability. As I stated at the beginning, this fundamental legal subject matrix provides only a generalized summary and is subject to many exceptions and crossovers with numerous other areas of the law. Note that this matrix does not distinguish between state and federal law in particular, which is also another helpful categorization that you might want to consider on your own. Please note also that we didn't include several other subjects that are very important that you may see in law school, and that may even be tested on various state bar exams. For example, family law, commercial law, and so forth. There are also many specialized areas of study and practice, such as banking law and securities law, some of which may have both litigation components and transactional components. I sincerely hope that this success tip has been helpful to you, and that it will help to provide you with a very real legal studies advantage.